Hi, I'm Phil Neale. Welcome to another quick video insight from Holmquist & Gardner. Today we're going to be covering settlement agreements in unlawful detainer actions. Please keep in mind that this video is for informational purposes only, and is not a substitute for legal advice. So the enforcement of certain types of settlement agreements has recently been brought into question by a case known as Princeton v. Allen. In this case, the landlord proceeded with an eviction based on a 3-day notice for a waste and nuisance. After the action was initiated, the parties, who are both represented by counsel, entered into a settlement agreement. Under the terms of the settlement agreement, the landlord was entitled to move for a writ of restitution if the tenant did not make payments in accordance with the settlement agreement. Sure enough, the tenant failed to make payments in accordance with the agreement, and the landlord moved for a writ. The court, however, did not enforce the settlement agreement, as the court held that the agreement violated the tenant's statutory rights, and accordingly stated that settlement agreements that seek to waive statutory tenant protections can be deemed invalid. So what does that mean for today's purposes? It does not mean that settlement agreements are impossible to enter into, but they tend to take a separate form. So what we tend to see nowadays is that parties will typically enter into agreed findings of fact, which will be submitted in and signed by the court. Thank you for joining us for today's quick video insight. Again, this video is for informational purposes only. We'll see you next time.